Court is now in session.
Good afternoon, everyone.
Good afternoon, Judge.
It's the matter of Maricopa County Libertarian Party versus Maricopa County et al. CV 2021-002205. Counsel for the plaintiff, would you state your appearance, please?
Good afternoon, Judge. This is Attorney Michael Kilsky appearing on behalf of the plaintiff, Maricopa County Libertarian Party. Its chairman, Brandon Slayton, is here on the virtual appearance with us.
All right, very good. Thank you. And counsel for the defendants?
Good afternoon, Your Honor. This is Joseph LaRue from the Maricopa County Attorney's Office. With me in the room is Tom Liddy and Emily Krager, also from the Maricopa County Attorney's Office. Your Honor, I want to apologize to the court for the way I'm dressed. I did not realize there was a hearing today, and I apologize for that.
All right, thank you. I appreciate that. Now, there's amicus that has been filed. We counsel for the amicus state their appearance.
Good afternoon, Your Honor. Alexander Colladin and Chris Biskovich, Colladin Law Group PLLC, here on behalf of proposed amicus Arizona Republican Party.
All right, very good. Thank you. Is there anyone else who needs to make an appearance? All right, very good. This is the time set for a return hearing regarding the application for an order to show cause. My goal here today is simply to talk about how we get to a resolution of the case. We're not going to discuss the merits, but simply the process towards getting to a resolution in the case. Let me turn it over to the plaintiff / petitioner to discuss their proposals. Mr. Kilsky? Mr. Kilsky, you're on mute, and I appreciate everybody muting their phones until it's your turn to talk. That'll cut down background noise.
Thank you, Judge. I apologize. Judge, I want to just summarize very briefly. I believe the questions before the court are pure questions of law. There are no factual disputes as far as I can tell. And so what I would ask the court to do is if the county wishes to submit any legal briefing on that, the court should set an extremely short timeline. The court should allow us to file a reply on an exceptionally even shorter timeline, and then the court should rule on the pleadings. There really isn't any evidence to be taken unless the county disputes our factual allegations.
All right. Mr. LaRue?
Thank you, Your Honor. I agree with Mr. Kilsky that this can be decided as a matter of law. There is a dispute about facts that I need to discuss with Mr. Kilsky. I will share it here, and I apologize, Mr. Kilsky, and also Your Honor. You may have heard we're involved in litigation with the Senate right now that is very fast-paced, and Mr. Kilsky, I simply have not had the time to make the phone call to you. Again, I didn't realize there was this hearing today. You're on my list. But we dispute the premise of Mr. Kilsky and the Libertarian Party's complaint that an audit of an election is occurring that would be subject to the laws that Mr. Kilsky has cited. And I can explain now to the court, or I can explain offline to Mr. Kilsky why we dispute that premise. But I want it to be noted, I guess, we don't agree with the underlying facts. We think that there are some facts in dispute. Nevertheless, we do think that the court can decide this as a matter of law. We don't believe that those disputed facts will really preclude the court from being able to get at the legal issue.
All right. So do we see this as somewhat of a motion for summary judgment. Is that what you're thinking, Mr. LaRue? Something in that format where the parties would propose findings of fact or factual issues that they believe are undisputed. The other party can either refute or acknowledge those, and then we can argue it as, or hear arguments on the basis of legal positions based on those undisputed facts.
Your Honor, I agree with a slight twist. What we had contemplated doing, as I said, was reaching out to Mr. Kielski, explaining what we believe his clients have misunderstood that might resolve this litigation. And if it doesn't, we anticipated filing a motion to dismiss because we believe that the complaint as filed has failed to state a claim upon which relief can be granted.
Okay. Mr. Kielski, any additional thoughts?
Well, again, I would urge the court, based on what Mr. LaRue just offered, if the court could set a deadline, let's say as soon as tomorrow by the close of business for the county to submit either what they say maybe a motion to dismiss or a response to our pleading, and then give us until, let's say, Monday or Tuesday for us to reply, and then the matter can be submitted and the court can turn it around as quickly as the court can get to it.
I think that's a little ambitious for us to achieve in practice. What I would propose is that today is Wednesday, February 17th. I'm asking the parties to meet and confer, and then come back to talk about the process, because I think that we're perhaps talking past each other a little bit without having the prior conversation to know exactly how this should be resolved. So have the parties meet and confer. Today is Wednesday. I'm going to ask that you meet and confer by next Monday, and then we'll come back for a continued return hearing. What have we got available sometime after Monday, early next week? Joel?
That we can do Tuesday, February 23rd at 9:30.
We can meet on Tuesday at 9:30 next week. That's the 23rd.
And Judge, that would work for me. I do want to let the court know that the clock is ticking on this, and the more time passes, the more the county is going to urge the court to say, well, too bad, too sad, it's already over, it's too late, nothing, if we violate the law, there's nothing the court can do. And so, again, I would urge the court really to, rather than set this as another return hearing, get to a point where the court is comfortable with issuing any orders that the court feels are appropriate. So if the court is not inclined with our suggestion that the state should have until Friday, which is almost 2.5 days, to submit its brief, then perhaps until Monday night, again, 3.5 days plus the weekend, and then we will submit something by Tuesday night, and then the court can decide it on the pleadings, rather than just have another hearing where we're going to talk about what we're going to do next. Meanwhile, county's going to announce, oh, the audit is complete, and they got a clean bill of health, even though all the parties have been excluded.
Well, the county's actions are obviously taken at their own risk. If they continue with something that is ultimately determined to be contrary to the statutes of the law, they will run the risk of consequences if that were to occur. I don't think the timeline that you've identified is workable, and I'm going to come back for a return hearing next Tuesday. So, sounds like the dates work for most folks. Mr. Colodner, does that work for you?
Your Honor, our calendar is open that morning.
All right, very good. All right, so we'll see everybody back next Tuesday. Perhaps you can confer and come to a resolution or see a stipulation. If not, we'll talk about a path forward to get to a resolution in this matter.
I appreciate
Thank you, Your Honor.
Yes.
I know Mr. LaRue and I will speak. We are known to each other, so I'm sure we'll talk about it.
All right, very good. Anything else to address this afternoon, Mr. Kielski?
No, I appreciate the board giving this its due attention. Thank you.
All right, thank you. Mr. LaRue?
No, thank you, Your Honor. And Mr. Kielski, I look forward to speaking with you.
All right, thank you. Mr. Quarles?
No, nothing further, Your Honor, except to inquire then if the court plans on ruling on our motion for leave to file amicus brief today or at the Tuesday hearing.
Probably at the Tuesday hearing, we'll take that up.
Thank you, Your Honor.
All right, thank you all.
Thank you, Your Honor.
Bye-bye.